Hmm. Hello, I'm Jonathan Bucky, a partner at the Dendros Group. Let's talk about the fiduciary responsibilities of directors of charitable organizations. Before we begin, let's get something straight. We are not lawyers. There are many fine lawyers out there, and your nonprofit organization should have one as a friend. This is only a guide and is not meant to prescribe exactly how board members must act in all situations. Each organization possesses a distinct composition and experiences different circumstances and outcomes. This presentation is merely provided as a reference tool and an outline to assist directors in performing their duties. It doesn't contain all the provisions, exceptions, limitations, and requirements of the law. For the exact requirements of the law, please refer to the source of the law. Get yourself good legal and financial counsel. Many of the guidelines in this presentation are taken from the Minnesota Nonprofit Corporation Act. While originating from the Office of the Attorney General in Minnesota, this content is also potentially relevant to nonprofits in other states. But it is not intended to represent all those resources available in the state or nationally. Further, this presentation is not a substitute for obtaining legal advice from your personal attorney. Under Minnesota law, directors of a Minnesota nonprofit corporation are responsible for the management of the business and affairs of the corporation. This does not mean that directors are required to manage the day-to-day activities of a corporation or to act in the role of an executive director. It does mean that directors must appoint officers and assign responsibilities to them so that the officers can effectively carry out the daily tasks of running the corporation. It also means that directors must supervise and direct the officers and govern the charity's efforts in carrying out its mission. In carrying out their responsibilities, the law imposes on directors the fiduciary duties of care, loyalty, obedience to the law. Minnesota courts have held that the law imposes the highest standard of integrity on the bearers of these duties. A director must actively participate in the management of the organization, including attending board meetings, evaluating reports, reading minutes, reviewing the performance and compensation of the executive director, and so on. Persons who do not have the time to participate as required should not agree to be on a board. Directors must establish committees having the authority of the board and may rely on information, opinions, and reports of these committees. Committees operate subject to the direction and control of the board. As a result, directors are still responsible for the committees and should periodically scrutinize their work. The director who is present at a meeting when an action is approved by the entire board is presumed to have agreed to the action unless the director objects to the meeting because it is not lawfully called or convened and doesn't participate in the meeting, or unless the director votes against the action or the director is prohibited from voting on the action because of conflict of interest. Written minutes should be taken at every board meeting. The minutes should accurately reflect board discussions as well as actions taken at meetings. A director should have general knowledge of the books and records of the organization as well as its general operation. The organization's articles, bylaws, accounting records, voting agreements, and minutes must be made available to members and directors who wish to inspect them for a proper purpose. A director should not only be familiar with the content of the book and records, but should also assure that the organization's records and accounts are accurate. This may mean the director must take steps to require regular audits by an independent certified public accountant. At the very least, the director should be aware of what the financial records disclose and take appropriate actions to make sure that they are proper internal controls. A director has the duty to protect, preserve, invest, and manage the corporation's property, and to do so consistent with donor restrictions and legal requirements. Instituting proper internal controls with the aid of the protection of assets. A director must assist the organization in obtaining adequate resources to enable it to further its charitable mission. A trustee of an organization, a trustee of a charitable trust, has a higher standard of care than a director of a nonprofit corporation. A trustee has the duty to exercise the care an ordinary person would employ in dealing with that person's own property. A trustee with a greater level of skill must use that higher skill in carrying out the trustee's duties. The director has the duty to investigate warnings or reports of officer or employee theft or mismanagement. In some situations, a director may have to report misconduct to the appropriate authorities, such as the police or the Attorney General. And where appropriate, a director should consult an attorney or other professional for advice. Traditionally, directors have had an absolute duty of complete, undivided loyalty to the organization. This means a director should avoid using their position or the organization's assets in a way which would result in pecuniary or monetary gain for them or for any member of their family. A director should put the good of the organization first and avoid engaging in transactions with the organization from which the director will benefit. Duty of loyalty. Under certain circumstances, a contract or a transaction between a nonprofit corporation and its director, or an organization in which the director has a material financial interest, is acceptable. However, if the transaction is challenged, the director will have the burden of establishing that the contract or transaction was fair and reasonable, that there was full disclosure of the conflict, and that the contract or transaction was approved by members or other directors in good faith. Boards should establish a written policy on avoiding conflicts of interest. A nonprofit corporation may not lend money to a director or the director's family members unless the loan or guarantee may be reasonably expected, in the judgment of the entire board, to benefit the corporation. In charitable trusts, transactions which otherwise might constitute a conflict of interest are permissible if the conflict was clearly contemplated and allowed by the original settlor of the trust. Directors of business organizations are under a fiduciary obligation not to divert a corporate business opportunity for their personal gain. A director of a nonprofit corporation is also subject to this duty. This duty means that a director may not engage in or benefit from a business opportunity that is available to and suitable for the corporation unless the corporation decides not to engage in the business opportunity and conflicts of interest procedures are followed. Other prohibitions relating to the duty of loyalty are specified in the rules of the Internal Revenue Code regarding self-dealing. These rules apply to private foundations. Directors have a duty to follow the organization's governing documents, articles of incorporation and bylaws, to carry out the organization's mission, and to assure that funds are used for lawful purposes. Also, directors must comply with state and federal laws that relate to the organization and the way in which it conducts its businesses. So that means directors should be familiar with state and federal statutes and laws relating to nonprofit corporations, charitable solicitation, state sales and use tax, FICA and income tax withholding, and unemployment and workers' compensation obligations. They should also be familiar with the requirements of the IRS. Directors should see to it that their organization's status with state and federal agencies is protected. Directors must comply with deadlines for tax and financial reporting, for registering with the Attorney General, for making Social Security payments, for income tax withholding, and so on. Additionally, if an organization is incorporated under the Minnesota Nonprofit Corporation Act, its directors have a duty to maintain its corporate status by submitting timely filings to the Secretary of State's office. Directors should be familiar with their organization's governing documents and should follow the provisions of those documents. Directors should be sure proper notice is given for meetings, that regular meetings are held, that directors are properly appointed, and that the organization's mission is being accomplished. Where appropriate, directors should obtain opinions of legal counsel and accountants. For more information, contact the Minnesota Attorney General's office. Thank you for your time.